This video is going to be looking at the House of Lords judgment in the 2007 case of the Crown and Kennedy, often referred to as Kennedy number 2 for reasons that I'll explain in a moment. Now, the legal context for our examination is the area of the actus reus, and in particular the requirement within some offences for there to be an element of causation, and we see this in offences that are referred to as consequence offences or result crimes. That is where the defendant has to have caused something to have happened. There has to be an effect. And in the case of Kennedy, the relevant result crime is that of manslaughter, and therefore for Kennedy to be criminally liable, he must have caused the death of the deceased in the case. Now, Kennedy is referred to as number 2 because it's the second line of appeal that Kennedy took. In the first line of appeal, he got as far as the Court of Appeal but was unsuccessful at that level. It was only owing to later doubts as to the soundness of the reasons for the Court of Appeal dismissing his appeal that the case was referred back to the Court of Appeal by the Criminal Cases Review Commission. Now, at the time of making this video, I haven't blogged about the Criminal Cases Review Commission, but I may in the future produce a short blog that explains what it is and what it does. But back to Kennedy, ordinarily I would advise you to identify the certified question from the outset of your analysis of a House of Lords case. But in this case, what I want to do is take the facts first and then add in the certified question. The facts here are relatively simple to explain. Kennedy lives in a hostel with other people. He visited one of the other rooms in the hostel, and 2 men were living in that hostel. And one of the men in the hostel said to Kennedy that he wanted Kennedy to make him sleep. Now, consequently, Kennedy prepared a syringe of heroin, which he then gave to the man who wanted to sleep, and the man injected the syringe. And this is quite important. So Kennedy prepares the syringe, gives it to the man, and it's the man who then does the injecting. Kennedy then leaves the room, and needless to say that the man dies in some way connected to the ingestion of the heroin. Now, Kennedy gets convicted of supply and he gets convicted of manslaughter. He denies both charges, but by the time of his appeal, he accepts that he is guilty on the more obvious charge of supply. But he continues to dispute his manslaughter convictions on particular legal grounds. Now, you may be aware from elsewhere that manslaughter can be brought either on the basis of an unlawful act of the accused, which then goes on to provide the foundation for the manslaughter charge, or on the basis of his or her gross negligence in the case. Now, here we're only concerned with that first variant, the unlawful act. And here we do have an obviously unlawful act, that of supplying the drugs. But as we're going to see when we examine the case, that particular act, albeit an unlawful one, has insufficient causal link with the death of the deceased in the case of Kennedy, and that's what we want to explore. I should say for now, if you're not aware of the distinction between the 2 manslaughter variants, I wouldn't worry too much about it at this stage, because it's likely that you're looking at actus reus in the first part of a criminal law module, and you'll look at the difference between the 2 manslaughter variants when you come to look at specific offences, which normally happens in the second half of a criminal law module. Suffice for now for you to focus on that actus reus aspect of causation, which of course requires an element of the offence, that is the accused unlawful act, and that unlawful act is the significant cause of death, or a significant cause of death. So it must be present, but also it must have this causative element. So, having set out the simple facts, let's have a look at the certified question. The question certified by the Court of Appeal for the House of Lords was, when is it appropriate to find someone guilty of manslaughter where that person has been involved in the supply of a Class A controlled drug, which is then freely and voluntarily voluntarily self-administered by the person to whom it was supplied, and the administration of the drug then causes his death. Now, jumping to the end of the story, the House of Lords answered that question succinctly and said, in the case of a fully informed and responsible adult, never. So Kennedy was not guilty of manslaughter. And he wasn't guilty of manslaughter because the chain of causation was broken. So what we need to now examine is how the House of Lords reached that conclusion that he did not, in effect, cause the death of Kennedy despite giving him a loaded syringe of heroin. And here the law shows its technical side to some extent because, of course, in a layman's sense, it might be considered that, of course, it was the supply of heroin that killed the deceased. But in a strict sense, that would be incorrect. And even the Crown on the appeal accepted that that was so. Because to hand over heroin does not cause death, no more than it does to pass someone a gun. Now, that's my analogy, not the court's, but I hope that makes sense. It's not the giving of a gun that causes death, it's what that person might then do with the gun. They might shoot someone else, or they might shoot themselves. And in this case, we're concerned with the shooting of self, or the administering of heroin. Now, it's agreed the supply can't be the unlawful act, and therefore the only unlawful act that one could find to build the offence of manslaughter on would be administering poison contrary to Section 23 of the Offences Against the Person Act 1861. And in order to establish this offence, it would be necessary to establish that Kennedy caused the deceased to take the heroin. And the problem for the Crown on the appeal was that the law, as the House of Lords recognised, assumes the existence of free will, particularly among adults. Informed adults are treated as being autonomous, and they're able to make voluntary, informed decisions. And so if we look back at that certified question, it stated that the heroin was freely and voluntarily self-administered by the person. And that was fatal to the conviction in the case, because whilst the appellant prepared the syringe, it was the deceased that took that free, informed, voluntary decision whether to inject or whether not to inject. And he chose to do so knowing what he was doing. It was his act that causes death, not that of the appellant. And because of this, the chain of causation was broken and the appeal was allowed. Now, that's the case of Kennedy, and I know that some of you will have broken down causation into factual causation and legal causation, and you will have done this during the course of your studies. And this case is an example where Kennedy is clearly the factual cause. He is a but-for cause. If he hadn't given the heroin, then the deceased would not have died. But he's not a legal cause of the event that takes place here, i.e. death, because there's a break in the chain. And the law does not find him to be criminally culpable in these circumstances, even though he's a but-for cause. Again, by way of analysis, if you've already studied omission liability with an actus reus, you may ask how this squares with the 2009 case of the Crown and Evans. And in that case, Evans was convicted and her appeal was upheld. Sorry, her appeal was not upheld. Her conviction was upheld. For the complete answer, of course, you'll need to read Evans, and it is a case that might well end up being explained on here. But in a nutshell, Evans was involved in supplying drugs to a 16-year-old who then overdosed, and that person was also a family member. Evans knew that that person was overdosing, and this is crucial. So she knew that there was a danger, whereas in Kennedy, he left the room and wasn't aware that there was any danger. Of course, there's a risk in taking drugs, but he didn't know that Kennedy was going to die in this case. Whereas in Evans, she knew that there was a danger and failed to arrange medical assistance. And what we have here is the liability by omission, i.e. not calling for medical assistance, on the basis of a duty of care. So because she had created the danger, she had a duty to fix that danger, whereas Kennedy didn't know there was a danger. It's also relevant, of course, that the deceased in that case was 16, so not an adult. And we see a similarity here in the case of Evans to the case of Miller, where the house is burnt because of a danger that the accused created and failed then to take measures to prevent that fire spreading in that case. But just go back to Evans to finish off. If you do look at the case, the other thing that you need to bear in mind is that in that case, Evans was convicted of the gross negligence variant of manslaughter, and that is exactly where we would expect to see the courts talking about a duty of care and finding a duty of care that existed in that case, but not one being present in the case of Kennedy. Kennedy is firmly prosecuted on the basis of an unlawful act, and the appeal proceeds on that way, and nobody suggests that Kennedy should be a gross negligence manslaughter case in the arguments that are made there. So that's Kennedy. I've put a gloss on it by looking at or making a comparison with the cases of Miller, which is explained on this website, and Evans, which may be explained at some later date, or it may have already been explained by the time you're watching this video.